Now, regarding the initiation of the case, we have said that an individual or a part or a group of individuals can initiate a case in the High Court or either in the High Court or in the Supreme Court. And there are provisions for litigation in the form of writ petitions also. And Supreme Court has taken cognizance of these facts of public interest litigation very efficiently, and they have pronounced judgment in many cases. In case of a public interest litigation, affirmative action may be taken by a court, not by a court, by court, either High Court or Supreme Court, in a public interest litigation. In public interest litigation, letters containing opinions of some internationally known scientists on the subject having impact on that subject in a public interest litigation may be taken into consideration while delivering judgment. Letters containing opinions of some internationally known scientists on the subjects and their views having great impact on the society may be taken into consideration for pronouncing judgment in such cases on public interest litigation. Then, jurisdiction of the Supreme Court may be invoked by a letter. That means if somebody writes to the Chief Justice, he will take this as a very important issue and he will definitely issue notices to the concerned parties if a class of the community is affected. His legal rights are violated. Appropriate scope to ensure availability of legal service or assistance should be there, and actually there is availability of legal aid, and this particular litigation called public interest litigation is mainly for the restoration of rights of the weaker sections. Public interest litigation can be filed in the form of writ petition for maintenance of approved standards of drugs or for banning injurious or harmful drugs. And there is scope of judicial review of a public interest litigation. A reviewed petition may be filed by the aggrieved party if he is not happy with the judgment pronounced by the court. In public interest litigation, the court can bypass the procedural shackles. Sometimes it might take to pronounce a judgment in an ordinary case, but in case of public interest litigation, court takes fast decision and they bypass the procedural, they can bypass the procedural cycles. Now, in one case, the Supreme Court observed that this court has always regarded the poor and the disadvantaged as entitled to consideration as special leave petitions of big industrialists. Oh, it's a very serious matter, and the court has observed such a beautiful thing. The special leave petitions, this court has always regarded the poor and the disadvantaged as entitled to preferential consideration than the rich and the affluent businessman and the industrialist. This is a very important point, and the reason is that the weaker sections of Indian humanity have been deprived of justice for long years. They have had no access to justice on account of poverty and ignorance and also illiteracy. They are not aware of their rights and benefits conferred upon them by their constitution and law. Therefore, Supreme Court felt that on account of their socially and economically disadvantaged position, they lack the capacity to assert their rights and they do not have the material resources with which to enforce their social and economic entitlement and combat exploitation. Therefore, Supreme Court in all the cases gave preferences to the underprivileged and the poor sections who are socially and economically backward. And it is the prerogative of the administrative jurisdiction of the Chief Justice to decide whether it can list the petition for speedy implementation, or it is an administrative jurisdiction of the Chief Justice for listing of a petition speedily. So this is very important. Chief Justice has immense power in the field of public interest litigation. Yes, Supreme Court is at the apex of the law, legal system, but still we must say that it is very important. Now, we can also say that the court has the power to enlist a complaint of non-implementation of statutory and constitutional obligation regarding children in observation home in larger public interest. This is very important. Destitute homes can be under surveillance of public interest litigation. Then Supreme Court and the High Court has the power. They have the power to interfere in the management of temples on a public interest litigation.